Hi and welcome to munshigiri.com. In this tutorial, we're going to talk about the amendments in the SEBI Act 1992. So you all must be aware that a new act named the Securities Laws Amendment Act 2014 has come into effect. And this act contains amendments made in the three acts, namely the first one being the SEBI Act, second is the Securities Contracts Regulation Act, and third is the Depositories Act. So in this tutorial we are going to talk about the SEBI Act 1992, that is the amendments brought by the Securities Laws Amendment Act 2014. So let's first have an overview of what SEBI is all about. Now the SEBI Act has a total of 7 chapters and contains 35 sections. It has two parts. Part 1 deals with the provisions of the law and the part 2 deals with the SEBI ICDR regulations, that is issue of capital and the disclosure requirements. Okay, the SEBI Act extends to whole of India, and this act provides for the establishment of an act which is named as the SEBI Act. Now comes what is the object of SEBI Act. So as far as the name suggests, it relates to the securities market, right? So the object of SEBI Act is to protect the interest of investors in securities, promote development of securities market, promote fair dealings by issuer of securities, regulate securities market, and monitor the activities of stock exchange. So we're just covering the overview. There is section 3 which talks about the incorporation of SEBI. Now the central government has been empowered to establish SEBI, that is Securities Exchange Board of India. SEBI is a body corporate. It has a perpetual succession and a common seal. It can acquire, hold and dispose of property. It can contract, sue and be sued. Now is constitution of SEBI. How many people are there in SEBI? That is covered under section 4 of SEBI. SEBI has a total of 9 people. 1 chairman, 2 members from the officials of central government, 1 member from the official of RBI, and 5 other members, out of which 3 shall be the whole-time members to be appointed by the central government. Now coming to section 11, which now you can say this is from where the actual act starts. Section 11 also there is an amendment in this section. Now let's look at section 11. Section 11 of SEBI Act 1992 talks about the functions of board. In its subsection 1, it talks about the duties of SEBI, and in the subsection 2, it talks about the specific powers of SEBI. So let's look at section 11 subsection 1. It talks about the duties of SEBI. It says duties of SEBI are: number 1, protect, number 2, promote, and number 3 is regulate. Protect the interest of investors, promote development of securities market, and regulate the securities market. Okay. So now section 11 subsection 2 talks about the specific powers of SEBI. Specific powers of SEBI. So SEBI has powers to regulate the workings of stock exchange, acquire the shares and takeover of companies, regulate the foreign institutional investors, and there are many other powers given to the SEBI to regulate as well as to prohibit the insider trading, prohibit fraudulent and unfair transactions, and promote self-regulatory organization, investor education training, etc. Now comes SEBI has been empowered, that is to call information for the purpose of inspection, conducting inquiries and audit of stock exchange, mutual fund, other persons associated with the securities market. Now comes the amendment part in this section. Alright. So let's look at the amendment. So we have covered that section 11 subsection 2 of SEBI Act 1992. It talks about the some specific powers of SEBI. So earlier we had under section 11 subsection 2 only. Earlier we had section 11 subsection 2 clause I. Now this section, it was earlier and now it has been split into two sections. Alright, split into two parts, that is, first is section 11.2 subsection IA and second is section 11 subsection 2 and clause IB. So alright, so first of all we are going to cover the earlier section, that is section 11.2I, and then we are going to look at what are the amendments in the section. So alright, so the now, okay, so this is section 11.2 clause I. The earlier section 11.2I read as follows. It says, calling for information and record from any bank or any other authority or board or corporation established or constituted by or under any central, state or provincial act in respect of any transaction in securities which is under investigation or inquiry by SEBI. Now this is an earlier provision. Now let's look at what is it after the amendment. Okay, so now after amendment, and this is after amendment, it reads as section 11 subsection 2 clause IA. This reads as calling for information, this is same, and records from any person, including any bank or any other authority or board or corporation established or constituted by or under any central, state or provincial act which in the opinion of board shall be relevant to any investigation or inquiry by board in respect of any transaction in securities. So now do you notice the change here? It is calling of information and record from any bank or any other authority. Oh, sorry for this thing. Alright, now got to cover both. So calling of information and record from any bank or any other authority or board or corporation established or constituted by or under any state. देखिए तो यहाँ पे है record from any bank or any other authority. Here we have is calling of information and records from any person, which includes any bank or any other authority or board, but this is not limited to the things mentioned here. So it can call, SEBI can call information and records from any person. Alright, so also central or provincial act which in the opinion of board shall be relevant to any investigation or inquiry by board in respect of any transaction in securities. This was not provided earlier in section 11 subsection 2 clause A. So if you clearly see that the scope of this section has actually widened. Earlier SEBI could call information only from banks or corporations established by central, state or provincial acts. Now information and records can be called from any person. So earlier under section 11.2 SEBI could call only information only in respect of transactions in securities which is under investigation or inquiry by SEBI. Now SEBI has power to call any information which in the opinion of SEBI shall be relevant to investigation or inquiry by board in respect of any transaction in securities. This was the first part that we discussed. Coming to the second part, that is section 11 subsection 2 clause IB. Okay, this is page 2 and we have section 11 subsection 2 clause IB. Alright, so it says calling of information from or furnishing information to other authorities whether in India or outside India, having functions similar to those of board in the matters relating to prevention or detection of violation in respect of securities laws, subject to provisions of other laws, for the time being in force. In this regard. Provided that the board, for the purpose of furnishing any information to any other authority outside India, may enter into an agreement or arrangement or understanding with such authority with the prior approval of central government. So this was about section 11 subsection 2 clause IB. Next is section 11 subsection 5. Section 11, next amendment is in section 11 subsection 5. Now this section has been newly inserted in SEBI Act 1992. This is newly inserted. There was no corresponding section. Alright, it talks about the establishment of investor protection and education fund. This is investor protection and education fund. So alright, it says the amount charged in pursuance to direction issued under section 11B. 11B we are going to cover after 11.5, okay, of SEBI Act or 12A of Securities Contracts Regulation Act or Section 19 of Depositories Act shall be credited to IPEF, that is Investor Protection and Education Fund, established by board, and this amount shall be utilized by board in accordance with regulations made under this act. That is, any amount charged in pursuance to direction issued under section issued under section 11B of SEBI Act or section 12A of Securities Contracts Regulation Act or section 19 of Depositories Act, it shall be credited to Investor Protection and Education Fund. An education fund, an Investor Education and Protection Fund is to be established by SEBI, and this amount shall be utilized by board in accordance with the regulations made under this act. Next amendment we have in section 11B. Section 11B. Okay, section 11B specifies the various grounds on which SEBI can make inquiries and can also issue directions to specified persons. Now, power to issue directions includes power to direct any person who made profit or loss by indulging in any transaction in contravention of provisions of this act or regulation to disgorge. So, alright, now an explanation has been, what I read was, it was an explanation inserted in section 11B. So, alright. So, the various grounds on which SEBI can make inquiries and issue directions, and an explanation has been inserted to section 11B. This is 11B's grounds on which SEBI can make inquiries. And issue directions to specified persons. Now it says, like issue directions, right? It has the power to issue direction. Now it says power to issue direction. Power to issue directions includes power to direct any person. Includes power to direct whom? Any person who made profit or loss by indulging in any transaction. DUL, by indulging in any transaction in contravention of provisions of this act, or regulations to disgorge. Now, disgorge means repayment of gain wrongfully obtained. So, this means that SEBI has power to issue directions to any person, alright? To any person. This is a very wide power that has been given to SEBI for the repayment of any gain made by that person in contravention of the provisions of this act or the regulation. This was the explanation that has been inserted in section 11b. Next comes is section 11AA, which talks about the collective investment scheme. Next amendment is in section 11AA, which is about the collective investment scheme. So there are actually total of 4 amendments in the collective investment scheme. So the section specifies that if the conditions given in section 11AA are fulfilled, then the scheme shall be called as collective investment scheme. So let's look at the 4 amendments that have been inserted in this section. The first amendment is, this is the first amendment, okay, not the first part. First amendment: any scheme or arrangement made by any person, and then the various conditions are specified. So any scheme or arrangement made by any person. Earlier, in place of any person, this was company. Earlier, this was company. So you see that now any scheme or arrangement made by any person, not only the company, if the various conditions specified under section 11AA are fulfilled, it will be called as the collective investment scheme. This was the first amendment. Second amendment is, it says any pooling of funds under scheme or arrangement which is not registered with SEBI, and involves a corpus amount of rupees 100 crores or more, shall be deemed to be collective, let me write it as collective investment scheme. This was the second amendment. Coming to the third amendment, we have as a new section 11AA subsection 2A has been inserted. Okay, insertion of section 11AA 2A. It says any scheme or arrangement made or offered by any person satisfying conditions as may be specified in accordance with regulations made under this act shall be collective investment scheme. What does this section specify? Any scheme or arrangement made or offered by any person satisfying conditions as may be specified in accordance with the regulations made under this act made under this act shall be collective investment scheme. And the fourth and the last amendment in this section is section 11 AA subsection 3. Now this section talks about the schemes which are not eligible to be collective investment scheme. So under this section it provides a list of schemes which are not eligible to be CIS. Okay, so earlier there were 8 schemes which were not considered as CIS. So we had 8 points, 1 to 8 points we had. Now a 9th point has been inserted in this section, which specifies that any such scheme or arrangement which the central government in consultation with SEBI specifies shall also not be considered as a collective investment scheme, besides the other schemes that are mentioned under subsection 1 to 8. So alright, it says any such scheme or arrangement which the central government in consultation with SEBI specifies shall also not be considered as collective investment scheme. This was about section 11 AA, the amendments made in this section. Coming to the next section, next amendment we have is in section 11C. This is section 11C, the next amendment. In section 11C talks about the powers of SEBI to order investigation. Now for that, the SEBI shall appoint an investigating authority, and the investigating authority has been empowered to seize the books and documents of any intermediary. Now for that, earlier the application was required to be made to judicial magistrate of first class having jurisdiction. So now there is an amendment in this clause. Now application is not required to be made to the judicial magistrate of first class. So section 11C, it talks about the powers of SEBI to order investigation. Powers of SEBI to order investigation. Now to order investigation, SEBI shall appoint investigating authority, and investigating authority has been empowered to seize the books and documents of any intermediary. Okay, now for that, earlier for the seizure of books and documents of any intermediary, the application was required to be made to magistrate, judicial magistrate of first class having jurisdiction. Now the same has been amended. The first amendment is, now this amendment in this amendment is, the first one being, after amendment the same is required to be made to Now this application is required to be made to magistrate or judge of such designated court in Mumbai. Designated court in Mumbai. So this was the first amendment. The second amendment in this section is, further a new subsection 8A has been inserted. It specifies that the authorized officer may requisition the services of any police officer or any officer of central government or of both to assist him, and it shall be duty of every officer to comply with such requisition. So alright, this is a new subsection, that is 11C subsection 8A, newly inserted. So alright, it specifies that the authorized officer who is an authorized officer, that is the investigating authority. The authorized officer may requisition the services of any police officer, or any officer of central government, or of both. For what purpose? The purpose is to assist him, and these people shall be duty bound to comply with such requisition, and police officer or officer of CG shall be duty bound to comply with such requisition. A great power has been given to SEBI under this section. So there is one more amendment in this section. This says, the third amendment, it says that wherever the word magistrate is used, it shall be substituted by the word the magistrate or judge of the designated court. Now that is very obvious. Like the application was required to be made to the judicial magistrate, so wherever magistrate is used, it shall be substituted by words the magistrate or judge of the designated court. Now these were the amendments in these sections. Now coming to the amendments that are there in the penalties that are imposed under the SEBI Act. So okay, this is page 5. Now coming to amendment in penalties. Amendment in penalties. So let's do it this way. Here we'll write this section. We'll look at the earlier provision, and in this column we'll look at the amended provision. All right. So this is first is section 15A. The earlier provision was the penalty under the earlier provision was rupees 1 lakh for each day during which default continues. During which default continues, or rupees 1 crore, whichever is less. Says whichever is less. Now, as per the amended provision, the penalty is not less than rupees 1 lakh, that is, minimum of 1 lakh shall be charged, not less than rupees 1 lakh, but may be extended to rupees 1 lakh for each day during which default continues. And this shall be subject to maximum of rupees 1 crore. So alright, the next ones are simple. Section 15B, this is same as section 15A. This is also same, amended as section 15A. That is, earlier the penalty was rupees 1 lakh for each day during which the default continues, or rupees 1 crore, whichever is less. And now, as per the amended provision, it is not less than 1 lakh, may extend to rupees 1 lakh for each day during which the default continues, and subject to a maximum of rupees 1 crore. Section 15C. Again, this is same as 15A. This is also same as 15A. 15D, same as 15A, same as 15A. Section 15E, again same as 15A and same as 15A. Now there is a change in section 15F. Section 15F talks about the three things, that is 3 defaults. The first is failure to issue contract note. Failure to issue contract note, that is, in case any broker or any intermediary fails to issue the contract note to the client. So alright, the penalty is same as above, same as in 15A, same as in section 15A. Again, this is also same as in section 15A. The B is failure to deliver security. Failure to deliver security to the client. Penalty, earlier it was same as 15A, and also it has been amended same as 15A. C is charging excessive brokerage. You must be aware that the brokers are not allowed to charge more brokerage than the specified rates, than the maximum brokerage that has been specified. Now for this, the penalty is, earlier the penalty was not exceeding 5 times the amount. Now it has been amended, it says not less than rupees 1 lakh, but may extend to 5 times the amount of brokerage. Now there is a minimum of 1 lakh penalty that will be imposed straight away. So okay, so coming to section 15G. So let's draw it once again. This column is for section, this is for the earlier provision, and this is for the amended provision. This is section, earlier provision, and this is amended provision. Now we have come to section 15G. 15G talks about penalty on insider trading. Penalty on insider trading. Earlier the penalty was 25 crore or rupees 25 crore or second was 3 times profits made out of insider trading, and this was the higher of above two, that is whichever is higher. Now this has been amended, and as per the amended provision it says not less than rupees 10 lakhs, but may extend to rupees 25 crores, or this was 1 and this is 2, or 3 times the amount of profits made out of insider trading. And in this case also we'll take the higher of the two, whichever is higher. It's coming to next section that we have is section 15H. Section 15H specifies the penalty for non-disclosure of acquisition of shares and the takeovers. This is non-disclosure. Penalty for non-disclosure of acquisition of shares and takeovers. Okay, the penalty is same as provided in section 15G, that is rupees 25 crore or 3 times the profit made out of non-disclosure of acquisition of shares and takeover. That is, these words shall be substituted in place of insider trading. Okay, so in this case the penalty, the amended provision is also same as 15G. Okay, so this was about section 15H, and we saw the penalty in this case. Coming to the next section that we have is section 15HA. Okay, this is penalty for fraudulent or unfair trade practices. Penalty for fraudulent or unfair trade practices. Earlier the penalty was same as in section 15G. However, now this has been amended. This is not same as 15G. So you need to learn that. So the amended is now the penalty is not less than rupees 5 lakhs. It may extend to rupees 25 crores or 3 times the amount of profits earned. Amount of profits earned out of fraudulent or unfair trade practices, whichever is higher. That is, higher of these two, whichever is higher. Next is section 15HB. Section 15HB. this is penalty for failure for which no penalty is provided elsewhere. That is where no penalty is provided elsewhere. Now for that, earlier it was penalty was it said penalty which may extend to rupees 1 crore, which penalty which may extend to rupees 1 crore, which may extend to rupees 1 crore. Now as per the amended provision, the penalty is not less than rupees 1 lakh but may extend to rupees 1 crore.